If I may begin in Hindi, so I was just listening to Mr. Adhir Ranjan Chaudhary ji, and all that has happened between 1995 till 2019, so far as this particular institution is concerned. So I was remembering, हमें तो वायदा करने की आदत है, वायदा पूरा करने की आदत है, चाहे तुम्हारा हो या हमारा हो. So they promised to set up an institution of international recognition. They promised that they will have Delhi as the center of arbitration, and litigation burden which this country is faced with shall be reduced. But all that could not be completed. Why? All that could not be completed because nobody bothered about the institution after it was set up. And all the money which was spent on the land and infrastructure and the salaries of the staff, etc., could only bring the result of 23 cases in 22 years. This is the achievement of the past government. And we were faced with handling of this institution. So when this institution was brought to us and it came to our notice, we tried to study every aspect of litigation, and we tried to study every aspect by which it can be corrected. So to begin with, if I may take the needle back a little bit in time, 2015, we brought out our legislation which was Commercial Court Division and Appellate Division Amendment Act. And setting up of those courts, High Courts Act, where by setting up we try to expedite the commercial disputes, settlements and their litigation processes in an efficacious manner. Then the second amendment was the Amendment to Arbitration and Conciliation Act, ACA 2017, and where a series of amendments, if I'm not wrong, more than 15-16 amendments happened in that Arbitration Act to again bring the process more favorable to the processes of arbitration and alternate dispute resolution. And what really transpired was to make India the hub of commercial litigation. And it is only premonition that a budget speech gets concluded and this bill comes up. So I see the linkages between the two, and linkages are that if India wants to get FDI, if India wants to progress economically, if India wants to be a global leader, then dispute related to money and finance need to be handled in an efficacious manner. Because if this is not handled in an efficacious manner, India as a destination for money and a place where investments can happen will always suffer. And it is for this reason that all these amendments in the economic structuring had to happen, and we as a government had already decided our roadmap, and one after the other we are bringing in these structural changes, and next structural change was to set up this particular institution. And when we were setting up this institution, Mr. Adhir Ranjan Chaudhary very rightly said that you've only changed the name, but what he missed out, it's that it's not just the rebranding which has happened by virtue of this bill. Rebranding has happened, but in addition to that, the entire administrative structure has been changed. And that entire administrative structure has been changed to identify areas where work can take over. And interesting enough, that impediment to the efficacious disposal of commercial cases was judicial overreach at times. Cases, there were twofold overreach. One was that while parties who are not in agreement of arbitration, but arbitrations are agreed upon in the agreements, in their settlement clauses, was the one of the two will approach the court, and by approaching the court impede the process of arbitration. The second aspect was while interim orders need to be granted, then those interim orders will suffer because a stay will be granted by one court or the other. And to get out of this particular impediment, changes were made in the ACA. And by those changes in ACA, we are at present in a new setup where the ad hocism, which was the currency of the earlier days was what was going on, and through ad hoc processes, the so-called arbitration mechanism in this country existed, and the burden on the court. I have a report, as per the Niti Aayog report, more than 1,400 plus days. It's a report by Mr. Vivek Debroy and Ms. Jain, which says that 1,420 days is what it takes for any litigation to happen, and for a claim of value dispute is 39.6%. Now this is a very, very high rate, which is higher than OECD countries, which is higher than South Asian countries, and globally we are standing at 178th rank out of a list of 189 countries in ease of enforcing contracts. Now, on ease of enforcing contracts, if we have this position and we are seeking global investment, ease of doing business we have improved upon and we moved a very big number, but ease of enforcing contracts still remains a dream. And to ensure that ease of enforcing contract happens, this is one such step, where an estimated number of cases pending before courts is 3.1 crore cases. So 3.1 crore cases which are pending in the courts, and the additional part of commercial litigation being before them obviously leads to the difficulties of commercial litigation. And so we had to find a solution in speeding up the dispute resolution, and that particular speeding up of dispute resolution comes from this particular bill. In this particular bill, there is a permanent structuring. So earlier center, which was working in Delhi, which was called International Center for Alternate Dispute Resolution, was actually ineffective, and I've shown you the numbers, that 23 cases in 22 years, and nobody ever revised that mechanism. It is surprising that when government is incurring that huge an expenditure, nobody ever revised either the expenditure or the mechanism. This particular method in which the bill was passed by Lok Sabha, and subsequently the bill lapsed because of the abetting of the houses and new election happened, and 17th Lok Sabha came in, the ordinance was brought in, and by shifting the ordinance and bringing it as a bill and an act, we are trying to make a statutory structure, and by virtue of making a statutory structure, all the expenses which are incurred on this particular center, and we'll be making it as an international center of excellence, will be subjected to CAG methodology, and auditing will happen through Comptroller Auditor General of India, by way of which there is a good mechanism, a methodology that efficacy can be tested and checked repeatedly, and this Parliament will definitely have a right over getting the details. Now, what was the importance of getting, and what was the need of getting this particular bill, and what is the target that we have set up? I have said it earlier also, I'm repeating myself, that this government is a government which is working with a plan, and the plan is to enhance the gross inputs and gross revenue, and stopping and filling the gaps that all the leakages should stop. Now, if we look at the litigation structure, we will find out that most litigation, and especially the commercial litigations that happen for arbitration, a lot of business is going to Singapore, a lot of business is going to London, a lot of business is going to Hong Kong, and all the 5 big bodies, Stockholm included, are the ones who are taking away our business. And because they are taking away our business, we need to stop that business from going there. Government of India is one body which is itself litigating at many places, and we are litigants, and including the fact that we are litigants in areas outside the country. It was a matter of surprise for me that London Court of International Arbitration had its office till 2016 in Mumbai, and it was operating out of Mumbai. Then Singapore International Court of Arbitration, International Chamber of Commerce had its center again in Mumbai, though it is doing only the administrative work and most of the arbitration proceedings are getting shifted to Singapore. Then ICC was operating here. Now all these big chambers are operating here, but what is happening to domestic and international arbitration in India? What is happening is that we have ad hocism, that somebody approaches the court, seeks an arbitrator to be appointed, somebody from the panel of local commissioners or something will be appointed, and that ad hoc method will lead to misuse of funds, no certainty of methodology, rules, etc. Somebody will, UNI, CITRAL, the UN code will adopt those rules, somebody will adopt their own rules, and this ad hoc process had to finish, and that is why this particular center is a center of great importance to bring in a shift in our thinking process and also the litigating process. Now, business of lawyers need not come out of courts. Business of lawyers can come out of arbitration proceedings. And to adopt that methodology, the mindsets need to change. And for changing those mindsets, this particular institution will go a long way. And to establish that, we set up a committee to look into all the aspects and all the vulnerable sections, that how and why India was vulnerable and why we were not able to get our adequate inputs into this process and why we were suffering that till 2016-17 other institutions were getting business out of India. Finally, B.N. Krishna report came, and B.N. Krishna report suggested many methodologies. Sri Krishna, I'm so sorry. B.N. Sri Krishna, Justice Sri Krishna. Justice Sri Krishna. My apologies. Please correct it. Justice Sri Krishna. Justice Sri Krishna committee report came in, and Justice Sri Krishna committee report suggested various methodologies and also discussed excessive court interventions. And excessive court interventions were one of the many things which were impeding the process and judicial interpretations which were leading to slowing of the process. And as per certain reports in 2001, 56,000 crore was stuck up in infrastructure development. 2011, 56,000 crore was stuck up in infrastructure development projects, and this money is the money lost. And I remember from my experience in Delhi that this bridge, which was to be signature bridge, which was to be completed in Delhi, was not getting completed. We've seen Bogibbil Bridge in Assam. We've seen Zolzila Tunnel. All these projects were not getting completed because there was some form or the other which were relating to disputes of contractors, etc. And if you look at the structure again, what was available to us, how do you deal with those litigation? Because if the time and money which is going to be consumed from trial court to the Supreme Court and commercial litigation, you lose out on money, project and time is of essence. The alternate dispute resolution mechanisms didn't exist in the format which is required. And because it did not exist, the process, the economy slowed down, GDP rates not being there, job is one issue which they keep talking about. So all these problems are interrelated. And to deal with it, we had about 35 institutions working in India. And when you, Sri Krishna committee sent various various forms to be signed by people across, and what was surprising is some of the so-called centers which were running dispute resolution mechanism didn't even have a proper website. They were not even answering those formats and answering any of the questionnaires. And all the chambers of commerce which are based out of various cities were the ones who were running this massive task of dealing with arbitration process. And in the name of national body, we had this International Center for Dispute Resolution in Delhi. And there was some branches in Mumbai and a couple of other places. So all that is what has been taken over, because this was a society, and this society came up as a society which was virtually non-functional in its true nature and wasn't really leading to the objective it was set up for. So objective they set up, we are the ones who are trying to achieve those objectives, and we are trying to achieve those objectives by working in seriatim, correcting various flaws, and in that process of correction, the correction also is to the statutory mechanism which has been sought to be brought in. So far as this particular aspect is concerned, why alternate dispute resolution? I remember one of the Chief Justices of Singapore, he once said that it is not alternate dispute resolution, but this is an appropriate dispute resolution. And this is an appropriate dispute resolution because of the amount of money and funding, because most of the companies will always have a panel of lawyers, and if they owe some money, a few 100,000 crores to a set of companies, they will refuse to pay that money because they always have a battery of lawyers who are on the payroll and can litigate. A small person suffers in these processes and will never be able to recover the rightful amount. So dispute resolution is one mechanism by which all sides win. The efficacy is maintained, the cost is less, and alternatively, the adversarial methodology which we adopt in the courts is also not there. The adversarial mechanism leads to a lot of bitterness, and that bitterness is reduced by this mechanism. And in alternate dispute resolution, there are various methodologies: negotiate, mediate, conciliate, and arbitrate. So arbitrate itself is beyond that dispute has happened. So first approach is preventive approach. So preventive approach, the three methodologies can work: that you negotiate, you try to conciliate, and adopt some methodology that there is no dispute. But finally, if dispute has happened, before making it a worse form of dispute that it goes to a litigating side, it should be brought before the arbitrator. Arbitrator is a neutral party, a third party, which will take a call on how to negotiate between the two parties and bring a proper mechanism. No injustice happens, and the award granted settles the dispute also between the parties, and parties can continue. In our country, we had a huge number of PMEs, public sector PSCs, public sector enterprise. So they have their own methodology, which they call permanent method of arbitrator, permanent body, which is dealing with arbitrations. But this permanent body is actually not under ACA. And because this body is not under ACA, the awards granted or dispute settled cannot be enforced in the court. So this itself was a big dispute and big problem. Then we had issues with BITs, bilateral investment treaties. And I remember when Prime Minister Modi ji went to Canada, and there was a BIT and there was a dispute regarding the earlier BITs which existed, and we tried to alter that aspect, and non-negotiations and other things happened. So BIT correction also this government has chosen to do, and we are focusing on multilateral treaties. So this center will be working as a composite center dealing with all aspects. And when we look at polity, I believe that policy decides on economy, economy decides on society, and society in turn decides on polity, and polity in turn decides on policy. So this interlinkage between, this is a cyclic circle, and this cyclic cycle, each side is impacting the other. So there is a symbiotic relationship between all. And if we really want to change the country, we really want disputes to settle, we want Sabka Saath, Sabka Vikas and Sabka Vishwas, then that cannot happen unless we have adequate economic worth. And that adequate economic worth will not happen until unless our global positions change, until unless our parameters change, until unless the way people look at us changes, and for changing all that, we have to change our ways also. And this is one way of changing our ways, in which we change the way we litigate. And the way we litigate is not necessarily through 10 years and 14 years of litigation in the court, but by bringing these centers in the country. And in most disputes, even the PSUs are in dispute with the government. So in most disputes, arbitration mechanism can exist, and government itself can be a body to promote that kind of arbitration. I'm surprised to know that all the whole lot of big industrialists, when they go for arbitration, a lot of them are choosing London over Delhi. They are choosing Singapore over Delhi. They may be choosing Stockholm, ICC, whatever, and Hong Kong. And the best is parties are all Indians. On all sides, parties involved are Indians. If parties are Indians, why have they chosen to go to Singapore? I think we all need to understand that also. We all need to understand that if there is a litigation between Indian parties, the companies are Indians, executors are Indians, then why is it that everyone is choosing to go out of the country? Why is the business going out of the country? Business is going out of the country because of the enforcement aspects, because of the impacts which it has, and the clarity methodology. So why ad hocism is chosen? Because there is no clarity that this is the time frame, this is the fee structure, this is the place where recordings can happen, this is the place where Google Hangout is possible, this is the place where you can have multiple bodies interacting with each other, the screen is available. The infrastructure itself is an issue. And from infrastructure to qualified arbitrators to qualified methodologies. I remember I was just thinking, I was talking to some youngsters, and the way they were discussing arbitration, the best is when they write papers on arbitration. The papers and the magazines where those papers are getting published happens to be Singapore, or happens to be London or Hong Kong, and no such magazine of repute or journal of repute is coming out of India. And when I was growing up, I remember I participated in one arbitration in early years of my practice. The arbitrator was a criminal lawyer who practiced criminal law, and the person arguing before him happened to be an engineer, because it was an infrastructure development issue. That was the condition of arbitration in India 30 years ago. And now when I look at the present day scenario, youngsters are traveling all over, they are writing papers, and they are participating in how to improve BITs in India. They are members of those committees and speaking about arbitration, and they say, this is the game changer. So I go back to the words of Swami Vivekananda, that youth of character is what he had faith in. And I think I also have the same faith, that youth of character and youth which is obedient, knows the rules, follows the rules, and will bring processes in a transparent manner, in a forward direction, and change the way we as a country and economy operate. And we as a country and economy operate is necessary to say, because boring.
The main question is.
No, I'll make it interesting.
The main.
Yeah.
Excuse me. The main.
Yeah, of course. My ears are, so I don't have issues with my ears.
The main question is regarding the reputed qualified arbitrators.
I'm coming to that, sir. I'm coming to that. So reputed qualified arbitrators is what this bill is also providing for. From infrastructure to the cost of litigation, speedier, cheaper, days, everything will be taken care of, and ease of doing business. So I'm coming to the aspect that what it is actually trying to bring, quality of experts in India. And that's why I narrated that incident of 30 years ago, where arbitrator was a senior criminal lawyer, and the litigation arguing counsel before the arbitrator was an engineer. And so the cost incurs were huge. And so what is the claim and what is the aim of this particular body, New Delhi International Arbitration Center? It is providing facilities and administrative assistance for conciliation, mediation, and arbitral proceedings. technical difference between each of the three stages, maintains panels of accredited arbitrators, conciliators and mediators. So it maintains a panel which is an authorized body which will be maintaining that. Then providing cost-effective and timely services for the conduct of arbitrators, promoting studies in the field of alternative dispute resolution and basically like a research body, cooperate with societies and institutions. There are various bodies, CII, FICCI, etc. All the commercial bodies which have industrialists on board, and these are the people who will be litigating. So cooperating with them in choosing arbitrators and all kind of facilities is what this is all about. And it is going to be a registered society to promote resolutions of disputes through alternative dispute resolution method and notified. So composition is what is very interesting. I've already spoken about finance and audit. Now composition is the proposed NDIAC will consist of 7 members, which will include a chairperson who has been a judge of the Supreme Court or High Court, or an eminent person with special knowledge and experience in the conduct of administration or arbitration, 2 eminent persons having substantial knowledge and experience in the institutional arbitration, 3 ex officio members. This is very important and interesting because it's including a nominee from the Ministry of Finance and Chief Executive Officer responsible for day-to-day administration of the NDIAC, representative from a recognized body of commerce and industry. So commerce and industry body also will have a representative appointed as a part-time member on rotational basis. So this is the structure. And by having a statutory status, it is also going to have the impact of what a statutory body usually will have. Coming back to the issue, I believe it is about 18 amendments which happened in the ACA to make it at par, and a certain aspect that post an award is granted, nobody can go to court. Maybe the court can look into it so that the government can look into it in rules, etc., so that the businesses which go out of the country to Singapore, etc., because they then cannot be challenged in the local courts, can be looked at. And so prevention to quick effective mechanism is what needs to happen, and to fully embrace the institutional arbitration is what we need to deal with. So 35 units which existed, and caseload is what is significant. I have already spoken about the PSC, PMAs and ACA not being enforceable in the courts is what is leading to the problem of efficacy and legitimacy. So all I can say is that the mission mode in which Government of India is working, the Prime Minister is setting targets for each one of us, including the ministers, and we all need to deliver on our promises, and that's how important deliberations need to be made to ameliorate the business environment in the country, and then the outcomes are in line with outlays. Otherwise, the outcomes will never be in line with outlays, and to improve all that, this is a policy move which will change the environment and the ecosystem in which commercial litigation happens and commercial development also happens. For every development, we need economy to be with us, and all I can say is, जी तो बहुत चाहता है कि सच बोले, लेकिन हिम्मत नहीं होती कि मेरी नहीं औरों की, क्योंकि इतने साल में 22 साल के अंदर 23 केस करने वाला इंस्टीट्यूशन, और उसको किसी ने चेक नहीं किया और कोई बोला नहीं उस समय कि कैसे इसको ठीक करना है. तो आज किसी ने बोलने की ही नहीं बल्कि करेक्ट करने की भी हिम्मत की है. सो आई सपोर्ट द बिल. थैंक यू वेरी मच.